I studied at the University of Ongoye,
Yes.
which was Zululand at the time.
When was
And
that?
That was I started in 1984.
84.
Then I completed in 1988.
Yes.
Then I went on to the University of KZN in Durban, where I did my LLB.
Yes. What then did you do thereafter?
After that, I actually worked for an NGO called the Community Law Center, where we were training paralegals. I did that while I was doing my LLB. And when I finished my LLB, I was asked to stay on for a time, and then I stayed for a year and decided that I wanted to do my articles after that.
Yes.
Then I got my articles with my current firm, Shepstein and Wiley, and left the Community Law Center to do articles with Shepstein and Wiley. But I had an arrangement with the Community Law Center that when I qualify as an attorney, I would come back and work for at least a year. So after qualifying as an attorney with Shepstein and Wiley, I went back to the Community Law Center and worked there for a year until June 1985 as a case coordinator.
Yes. Very briefly, what did that center actually do for the community?
We were
I asked because my eyes were only opened to the role of paralegals last year. So very briefly, what are the essentials of the role of a paralegal?
The paralegals were actually getting elementary legal knowledge. So we would train them on the basic legal knowledge so that they could go out and advise members of the community. And at that time, there were pertinent issues which affected people in the rural areas particularly, because that's where we concentrated. Issues of people not getting their pensions on time, not having anywhere where they could go to actually lay complaints. So they came in very handy because they advised them with regard to that.
What else? What other sensitive issues that often frustrate people did that center or do centers of that nature help the community with?
Yeah, well, our focus was in the rural areas particularly. So issues of family were also a problem. You know, people would have problems within the family, breadwinners not being there, not being able to, you know, have enough resources to put food on the table, or there'll be disputes affecting members of the same family. So that came in as a very useful resource in trying to resolve those problems. And where we could actually mediate amongst, you know, members of the same community. And we were relying quite a lot on the cooperation of the chiefs or the traditional authorities at the time, because before you could go there and do anything, you had to go there, you had to get their go-ahead.
Yes. And I know the answer to my next question might appear to be obvious, but I think it's necessary. Were you being paid anything, even a token for fulfilling that role? Were you, in other words, being paid by those you assist?
No, we're relying on donations, actually. So it was a free service for the members of the community. Then because we needed, you know, funds to go around, vehicles to travel, because those were far out areas in KZN, and some of us were from Gauteng. I'm originally from the East Rand.
Yes.
So it was a foreign territory for me. So we had to get acquainted with the area. And the resources were actually, there were quite a lot of donors at the time who were funding the type of activity that we're doing.
Is it fair to assume that the center paid you fairly well?
Not fairly well, but there weren't many jobs going around at the time. And we were actually looking at the bigger picture of making a difference.
Okay.
So it didn't bother us much.
So in a nutshell, what is it that drove you to work for the center, notwithstanding the fact that you were not particularly well paid?
I think we were driven at the time to make a difference in whatever way we could. It was a small contribution, but it was a contribution nonetheless. So as a student, we were actually helping people anyway, because people were having a whole lot of political problems, being harassed by the police and all sorts of things. So in this case, at least, we were getting some form of income. And at the same time, we felt like we were being lawyers, which gave us some satisfaction.
Yes.
Because once you've assisted people and you can actually see that they've actually benefited from what you did, it gives you some level of satisfaction.
And you have been practicing law for some time?
Yes, I have.
As what and for how long?
After I finished my stint at the Community Law Center, I returned to Shepstone, and of course, I then had an arrangement with Shepstone and Wiley that when I finished my stint at the Community Law Center, I should come back and work as a lawyer. So I did that and went back to Shepstone and Wiley in 1995, in June. And I worked as they used to call us professional assistants at the time.
Sure.
That means you have just qualified. In 1998, I was admitted as a partner of the firm, and I've been a partner ever since. So I've been there for about 25 years now, for 24 years.
Just a quick question in passing. Why is it that it appears to be impossible for black lawyers, black in a generic sense, to form big firms? Why does it look like they all just get absorbed by big white firms, or it will be at best a three-partner firm or three-director company? What is the problem, very briefly?
I think
To help fast-track transformation, that's what I'm gearing at. What is the problem?
I think the problem is we want rewards too quickly as black people. I think it's something that we still need to work on. Because in a bigger picture, if you work in a firm, you need to realize that you actually work for a collective. And it doesn't mean that you have a kill what you eat scenario where you say, I actually bring this much, so I need to get the same much, which will be commensurate with what I'm bringing in. What I've realized is that if you accept that you actually work as a collective for the general good, and there may be times when you bring in more and not expect to get out more, that's the realization that's going to make us, as black professionals, stick together if we decide to form a partnership.
Yes.
Over the years I've been at Shepstone and Wiley, there have been quite a lot of guys that we were at varsity with who've actually showed an interest of forming firms, which was a good gesture. And in most instances, it would actually take off. And those of us who are in big firms would actually assist in facilitating the process. But a few months or years down the line, you find that squabbles start showing. And mainly they are based on, no, I bring in too much, and people are actually taking off more than what they are bringing in, and it's not fair, so I can do better on my own.
Yes.
I think the minute we move away from that thinking,
Yes.
black firms are going to thrive.
Well, that's a side issue, a necessary side issue, just so that you relax a bit. Let me wrap it up with this question. Why is it that you are absorbable? You are able to work in these big firms, and they give you whatever they think is appropriate for you, no matter how much you bring, and yet, when you are alone, you can't do it. Why is it that you didn't march out of that big firm, join up with those struggling partners, form something formidable, with the benefit of your experience in that firm, grow it, encourage others around the country to do likewise? What is the problem?
excuse me, Chief Justice, are you saying why am I not personally doing that?
Yeah, why didn't you step out of the partnership, just as an example, for instance, to go join them and strengthen this thing?
Yeah, you
Or
see-
haven't you seen the need?
No, I have seen the need. You need to find people with the same type of thinking.
Like-minded people.
Yes.
Yes.
Now, if you find people who are actually not thinking the same way, and you leave what has
Sure.
become your familiar
Sure,
enclave,
sure.
and you get to a point where you're on your own, or you actually are doing things the way you think you should, but nobody else is actually pulling in the same direction.
Yes.
It ends up actually disadvantaging us as
Yes.
black professionals, because, as I say, I had people who had very best intentions
Yes.
who did exactly this, and I've always been very supportive.
Yes.
And then a few months down the line, they phone you to say it's not working well because so-and-so is actually, being selfish or wants to take out
Yes.
too much. And I think we need to change as black professionals.
Yeah, for what it is worth, I find it strange that we can form political parties, they work, we can form all sorts of things, they work, regardless of how much everybody contributes, and yet when it comes to money-making ventures, there seems to be a problem. But anyway, I think you've answered. Now, how did you equip yourself for the position you've applied for now?
Position of?
That you have applied for. Just boast a bit, give us your credentials, emphasize as much as you want to so that we really understand that Mr. Nkosi is up to it.
Okay, since I went back to Shepson and Wiley back in 1990 or 1995, I've litigated in the High Court. I was responsible for my own matters, and I happen to specialize in what I do. And in order to place myself in a position to
And
do
what is that?
local government and administrative law. So in order to equip myself in doing that effectively, I had to read as much as I can, get to know people as much as I can, get to meet clients and find out what their problems are as much as I could. And through the litigation that I've done over the years, I've rubbed shoulders with counsel, senior and junior. And in most instances, because most of them are not too familiar with what I do, I would actually have to assist them in preparing for the cases that we were doing. And throughout the process, I don't rely on counsel to actually come up with answers in my cases. If it's my case, I need to know it more than counsel will do. We can exchange ideas in terms of how the case is to be handled, but I want to be hands-on in all my cases. So all counsel that I've briefed will know that I know as much as they do when it comes to my cases. Then in 2011, I was approached by the then Judge President to request that I make myself available to act. For me, it was jumping into the deep end because I had not done it before, but because I had litigated in the High Court throughout, it was no problem at all. I actually hit the ground running, and I was prepared to go to the other judges who were there at the time, if I'm not familiar, or if I was not sure of anything, to ask them. And I must say they were very helpful in guiding me through the process. I've been doing it almost annually for about last 7 years now, and I've learned a lot from the judges who've worked with me. And I think they've actually found out that I'm a team player. I'm always prepared to learn. So I'm very well equipped. And questions were asked as to, having acted all these years, why didn't I make myself available? I personally felt that I was not ready yet. I feel that I'm ready now.
Have you had any problem delivering judgments within a reasonable time, reserved judgments?
No, the least I've waited with the judgment, if I'm not mistaken, was a month.
Yes. And just to
The
clear
most, I
something.
beg your pardon, Justice.
I
The
beg your
most
pardon?
I'm saying, I said the least. The most, or
Yes.
the longest period I've waited, I think,
Yes.
was a month.
Yes. Just to take something out of the way, your directorship, you seem to express doubt whether you ought to resign the directorship or not in the event of your appointment. Have you reflected further on it?
Yes, I have no doubt that I'll be prepared to resign if.
Is it prepared or is it something else?
No,
Are you
I will
uncertain?
resign. Unless I'm allowed to stay, I will resign from my directorships if I'm appointed.
Yes. Thank you. DJP?
Thank you, CJ. Mr. Nkosi, good afternoon.
Good afternoon, DJP.
How are you?
I am very well, thank you. And how are you?
Yes. How many times have you acted in crime?
Actually, I acted in Durban once, and then I did, because now it's mixed. I was given civil throughout, but when I was acting now in January, I did both crime and civil.
So how long did you do crime in the previous session?
Well, in the previous session, I did it, I think it was for a period of 2 weeks. And before then, I did it for the whole session in Durban. That was the first time I acted.
So with such an experience and exposure in criminal proceeding, can you safely say that you are now a well-balanced judicial officer?
Yes, I can. I mean, when I did crime the first time, I actually had an assessor with me, and we were allocated, if I'm not mistaken, 5 crimes to do with 5 criminal matters to do within a week. And for our luck, all our matters ran. And by the time I finished my stint, I delivered all our judgments. And I had no difficulty whatsoever in dealing with all the matters that were allocated to me.
Okay, maybe you can give me some clarity on this. In the answer to your questionnaire, you indicate that you appear in court occasionally, mostly to note judgments and to argue urgent applications.
Yes.
So, have you been involved in any trial proceedings?
Like I said, I'm always involved in trial proceedings. When it comes to preparation, I'm hands-on. I prepare all my cases, and I'm actually there. And if there are issues to be found out, I make sure that I do.
I mean on your own?
On my own, run a matter on my own?
Yes.
No, I don't think it's actually advisable for any attorney to do that. If you actually are a litigator, I think it's in the interest of your client that if you have a chance to brief counsel, you give your client the benefit of having 2 minds looking at the same thing. Because if you act for a client as both attorney and counsel, you tend to develop blind spots. There are issues which you overlook, which counsel, if you had one, would have actually pointed out. Because what tends to happen is that as an attorney, I tend to become too emotionally involved with the issues of my client. And I see the whole case through the lenses of my client. And then I tend to concentrate on what's before me in favor of my client, only to find that there are issues or cases that I had not actually dug deep enough to find out so that I can look at the matter from both angles. So having counsel helps in doing that. There are instances when I thought our case is waterproof, only to find that when I sit down with counsel, the shortcomings that are pointed out gives me the indication that I need to go and dig deeper. And my clients have always benefited from that.
Okay. During your acting stint, have you come across a situation where we had to develop customary laws so for it to be in line with constitutional values?
Yes, I've had quite a few cases involving customary law, and I've dealt with them quite well.
As a practicing attorney or as a presiding officer?
As both. No, not as a practicing attorney. I specialize in local government and administrative law. My clients are, institutions. But as a judge, I've had customary cases that I've dealt with, and I've dealt with very well, with them very well. I've never had any complaints.
Okay, thank you, Chief Justice.
Thank you, Deputy Judge President. MEC?
Thank you, Chief Justice. Looking at the racial and gender demographics of the KZN High Court bench, you realize that transformation is necessary.
Certainly, yes, I do.
Please tell us what contributions have you made to empower the previously disadvantaged colleagues in your profession, especially women in particular, over your long period of service in the legal profession?
Okay, when I went back to Shepson and Wiley as a lawyer back in 1995, as I said, I had this department that it was there, but I had to refine it. So it's local government and administrative law department. It's a small department because of the specialized nature of our work. So I have an associate attorney or professional assistant, as we used to call them. I had a paralegal, and I'll have a candidate attorney who also helps with the running around stuff. Since that time, I've always had black professionals in my department to assist or to be part of the department. So as a big partnership, we have a policy in terms of how we recruit people to come into the firm. But as a black senior partner, I made sure that I lead by example. So I've always had black professionals working in my department, and I've trained them very well. And those who left went out to join parastatals or to practice on their own account. And the reason they left is because they actually had to be headhunted because of the training that they got from me. So I've done quite a lot to actually make sure that I develop other black professionals to be in a position to do what they've been trained for.
Thank you, Chief Justice.
Thank you, MEC. Commissioner Mpofu?
Mr. Nkosi?
Good afternoon, Commissioner Mpofu.
Yes, thank you. Yeah, I'd like to maybe further develop a point that the CJ alluded to, but from a different angle. The white firms, or historically white firms like the one you work for, are notorious for not briefing black counsel or black women counsel. Now, there's an expectation, legitimate or otherwise, that people like yourself who are highly placed in those firms would either back that trend and do something different or influence the mentality. We know where the mentality comes from. We don't have to go there. So, and you said you try to lead by example. So transformation for me has got, we spoke this morning about empathy. There's this other phenomenon, which is what I'm asking you about, called kicking the ladder. In other words, you climb and you make it there in the big white firm, and you are a partner and so on, but you kick the ladder down, and nobody else is supposed to go up it. From the point of view of your subordinates, you have answered the question. So I'd like to know whether you've done anything remarkable in relation to briefing black counsel.
Yeah, I've actually, the first counsel I look for, if it's a matter that I have to litigate on at the High Court, is a black lawyer. I've briefed black lawyers who actually did a very good job and for me, to the extent that I can the next day go to my client and say, we use this lawyer again. And most of the time, you find that people, because as I said, I specialize in an enclave, which is not familiar to most lawyers. So once I've developed that database of lawyers, the difficulty is getting them being available. The senior lawyers that I've used and who actually did a very good job for me, to the extent that I had my clients wanting to use them again, you find that you go back to them, they are no longer available. And you check around and you just can't find lawyers. So I think black senior counsel who are black also need to make sure that they make themselves available so that people like us who are in these big white firms should actually be able to utilize them. Because what happens is that I end up having to go to the very same white law advocates I used previously because the ones I was hoping to get are just not available. Last year I waited until the end of the year for counsel who had done a very good job for me, who's black, and he was too busy, and my client was prepared to wait until early this year, which is the time we finally actually got to have a consultation. So I think we need to do some introspection as black advocates as well, that we don't stretch ourselves too wide in terms of our availability. We also are available to take work from those big white law firms, because it gives you that substance or quality of the work that will make you thrive as an advocate.
Yeah, no, the point taken. I'm more concerned about not those people who have that good problem to have. I'm concerned about what we call baby juniors in the profession. You know what that means, yeah?
Yes.
Particularly black women who come to the bar and have to leave, very competent people who have to leave at alarming rates simply because they're not given work, not fancy work, just work to survive and cut their teeth and, you know, even magistrates court, you know, this and that. That kind of effort, that's what we would expect, particularly from the bigger firms, because you have the pool of work.
Yeah.
In other words, outside of your department, you'd be able, just because of your clout within the firm, to influence that kind of thing.
Yeah. As a firm, we have a policy that in matters where we can have black, female advocates available for matters which actually are not too complex. You know, we don't want to throw them into the deep end if it's a complex shipping matter, for instance. But if it's a matter which a black male or female can run with, so our policy is that that's our, where we should start. And personally, I've actually, whenever I have a matter that's not too complex, where I start is to look for female black counsel to brief. And if I don't find them, I go on to see if I can find black male counsel to brief. And if not, then I have to go back to the usual white counsel.
Suspects.
Commissioner Namen.
Thank you, Chief Justice. Good morning, Mr. Nkosi.
Good morning, Commissioner.
Sorry, I'm just need your comment on an article that you wrote about a judgment that the Constitutional Court gave. I'll read the paragraph that concerns me, and I would like you to just explain it.
Yes.
You dealt in that matter with an article in a matter of Abahlali Basemjondolo. It dealt with the Slums Act, am I right?
Yes.
And then you say in the paragraph, in the circumstances, which is the last paragraph of your article, one can only hope that the finding of the unconstitutionality against the provisions of Section 16 of the Act was not an attempt by the Constitutional Court to split the cake, in quotes, in order to appease the Abahlali, to ensure that it did not go back empty-handed. If that was the case, then such a gesture, noble as it is, would be based on reasoning which, in my view, is legally flawed.
Yes.
What did you mean by that?
I meant that we need to, as a judiciary in our country, we need to enrich our profession to make sure that the judgments which are delivered by our highest courts are have substance. So we should guard against delivering or giving judgments which are just going to make people feel happy that we did not actually lose out completely. So if the reasoning was that there was an issue of legal substance in what that judgment said, I'm all for it. But when I looked at the actual reason that was given by the Constitutional Court at the time, it just didn't make any sense to me.
Okay. So in other words, you believe that the Constitutional Court is capable of just appeasing litigants.
No, I'm saying it should guard against the risk of doing that.
No. You have said now, Mr. Nkosi, in answer to my question, that you felt that the judgment did not make sense. The reasoning did not make sense.
Yes.
So if then the reasoning didn't make sense, is that the highest court in the land of this country, according to you, is capable of giving judgments that do not make sense, first of all?
Well, in
and
this-
secondly,
Yes.
please, if I may, and secondly, it is capable of appeasing litigants.
Judges in the Constitutional Court are human. They are not infallible, so they can make mistakes like everyone. And if, as lawyers, we scrutinize those judgments and there's something that we think is missing, I think we're more than entitled to do that, because we know it's not destructive criticism. It is constructive criticism, which is aimed at the court having self-introspection to guard against falling into the trap. I may be wrong, I'm also an individual, I'm not saying I'm always right. It was just a view which I expressed to other colleagues. So if I'm wrong, so be it, I can accept that. But I felt I was entitled to express a view.
Yes. But just one last question, thank you, if I may, Chief Justice. You had drafted the Slums Act, am I right?
Yes, I did.
So it was your own baby, and then the court had found that it was invalid, and then you had to make these kind of comments because it was your own baby. According to you, there was nothing wrong with that act.
No, whoever drafted the legislation, if it actually had a flaw, if the judgment relating to it had a flaw, I'll be entitled to comment on it. I was not barred from commenting on it just because I drafted the legislation. If you think of what the court said in that act, is that it actually ruled that one section is unconstitutional. And that section said the Premier could order a municipality or a landowner to remove people if the occupation or if the occupation of their property is problematic, as said by a municipality. And the court said for that reason it's not in compliance with PI. What didn't make sense to me is because in the legislation it says whenever you remove people you do it in terms of PI. So how can it not be in line with PI if when you have to do it, you have to follow the route that's set out in PI?
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Nyambi?
Thank you, CJ. Afternoon, Mr. Nkosi.
Good afternoon, Commissioner.
Understanding the hierarchy of judiciary in South Africa, taking it from the last question, what will be the intention of criticizing judgment of Constitutional Court?
It's just to enrich our jurisprudence because, as I say, judges in the Constitutional Court are not infallible. I can be appointed to the Constitutional Court at any stage, and it doesn't mean that by taking office in that court, they then become infallible. I may make mistakes which other lawyers can bring to my attention, and it could be justifiable criticism. It was just criticism, nothing. I knew the court could not change its judgment just because of me. I'm just a lawyer from Durban. But what I thought the court would do is just to look at what I'm saying and decide if I'm talking nonsense or not.
What will you regard as your weakness?
My weakness? Maybe I'm too impatient at times when it comes to getting things done, and I tend to worry if things are not done within the period I expect them to be done. But other than that, I think other people can answer that question better than I can.
My last one is your worst experience as a legal practitioner in South Africa.
My worst experience actually occurred when I was acting as a judge, and the case that I was presiding over, a criminal case, was not investigated properly, and there was evidence that I thought should have been gathered and wasn't gathered. And the prima facie view was that the accused in the case had some case to answer, But because of that missing evidence, I just couldn't get them to answer the way I thought they should. And I had to watch them go because I could not convict without evidence being put before me to enable me to do that.
Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Nkosi.
Thank you, CJ. I note that you have been nominated by Advocate G.D. Gottdat.
Yes.
How is one of the counsel that you brief in your office, or what is your relationship?
He's acquired expertise in the law I specialize in. As I said, I specialize in local government and administrative law. And when I brief counsel, they end up acquiring experience in the law that I practice. So over the years, when I have matters which are complex enough to require senior counsel, I would use him as one of the advocates I would consider for those cases. So over the years, we've developed a friendship, not the type of friendship that you invite me home to a bride sort of friendship, but on a professional level where we actually respect each other as professionals, and he respects me as an individual. He's actually observed me acting on the bench as well, and he's one of the people who've been impressing upon me that I should make myself available.
Some of the questions that you have been asked relate mainly to transformation and our efforts as a profession in ensuring that we accelerate transformation. I note in the questionnaire that you are neither a member, you neither belong to PLA or to NADEL or any of these organizations that advance or champion the cause of transformation. Is there any particular reason?
No, there isn't. I think I'm just as capable to make a contribution without belonging to any organization. I actually have belonged in organizations throughout my life. During the period prior to 1994, I belonged in organizations. And you got to a point where you belong to organization A or B, and then it seemed as if you're not in A, then you're against B. So to avoid the situation where I look at people who belong in a different organization as them, and me in belonging in another organization, I think I decided to make my contribution from outside organizations. And so far, I haven't had a problem with that.
Lastly, I'm not too sure yet, so that's my last question. I understand your question. I'm sure Advocate Mpofu here is quite happy that attorneys you advise attorneys to brief counsel mainly for a second mind and all that. Bearing in mind the introduction of the Right of Appearances Act, where attorneys were allowed to appear in the High Court.
Yes.
And also taking into account the obligation to contribute in transformation and also develop the skills. Why would you regard the appearance by attorneys in court as something? And lastly, there's this issue of categorization from your part, where you say on less complex matters, you would brief female, black African counsel. As it goes up, I'm not too sure what is that measure of complexity on your part. If it's more complex, you go for maybe for grade 1 counsel. I don't know what will.
No, I'm not saying there's anything wrong with it. It's like a GP saying that I'm not going to use a specialist because I can as well do an operation. The fact of the matter is that the patient may not get the benefit of two people looking at the problem. So what I'm saying is if you feel the means that are available to a client warrant that you should actually have an attorney appearing as both counsel and advocate, by all means, you should do that. It's in the interest of your client. But if you have a client who's saying that I don't necessarily have a shortage of resources, just win my case, why should you deprive that client by me appearing as an advocate as well after having done work as an attorney And when I lose the case, it actually transpires that there are things I overlooked.
There's this last portion which you have not answered. There's this categorization of complex and less complex of your matter. You say you brief a black, you look for a black junior counsel, but particularly female, if the matter is less complex, it's just an easy matter, you look for them.
No,
but what is the basis, I mean, what is the measure of this complexity that we're talking about?
Maybe the way I put it came out wrongly. I don't mean the sense that blacks should only be given less complex matters. If you deal in specialized, if you specialize in law, there may be cases which are more complex than others. There may be other cases which are just run-of-the-mill cases, but other cases may require actually in-depth knowledge on the part of the person who's going to argue the case. And it does not necessarily have to be a black or a white lawyer who's going to argue it. If I go to a black practitioner or advocate, I won't go to an advocate who qualified last year and say to them, I want them to go and argue a case that involves my client having to lose, let's say, 50 million if we lose the case, because of these issues which could go either way. And I actually want to promote transformation, so I think you're the right person to argue it. Because if they lose it, I'm going to be the first one who's going to point a finger. So I'll go to a person that I know is going to be in a position to better argue the case for me, black or white, knowing that I'm going to be in a position to go to my client and justify whatever result we get from the case after that. Because my clients also do ask, when I brief counsel, I act for clients, when they always ask, but how experienced or how, conversant is this counsel in the case that we're facing? And the last, or the worst answer I can give is that, no, well, they are black, but I think, it's only fair that we give them work to do. I have to be in a position to justify it.
Commissioner Didiza, thank you very much, Commissioner Nkosi.
Thank you very much, CJ, and good afternoon, sir.
Good afternoon, Commissioner.
I was maybe going back to the issue of PI and your own reflections after the judgment of the Constitutional Court. Has it ever occurred to you, maybe looking at that judgment broadly, that it might be necessary to look at an omnibus legislation that deal with land matters, given that currently you have got various pieces of legislation that deal with the issue of land and property development in particular, that lie in a number of spheres of government. Some of them it's ordinances or bylaws, and the others relates to the disposal of land, which may have a concurrent function between national and provincial government, and yet some of those, occur in the local sphere. You also have got legislation that deals with farm dwellers, Extension of Security of Tenure Act, which in part also may touch issues of PI. I can go on and on. I'm just trying to hear your views at whether or not is it something that you think is doable, is necessary. In the US, for instance, you have got the Farm Bill when it comes to agriculture, which is an omnibus that relates to all agricultural acts as a way of ensuring that you can actually have consistency in how those matters are dealt with, whether at federal or even at the state level. Thank you.
I think the legislation we have in place is more than adequate to deal with the problems that we're facing. I don't see any problem with PI being implemented to actually make sure that it serves the people it was supposed to serve. And it actually puts in place the measures that are necessary to safeguard the rights of people to occupy land. If you devolve legislation too much, then you end up running the risk of having it, of getting it too fragmented, to the extent that you get Area A applying it their own way, Area B having their own different application or interpretation. What the move now is actually to centralize legislation, like in the case of local authorities. We had ordinances being applicable in various provinces. But since then, we have legislation being centralized at national level, the SPLUMA particularly, which actually means that in all the areas or all municipalities within the country, the legislation that needs to be applied is uniform. So I'm not sure if I've answered your question correctly, but in my view, I don't think we have a shortage or a lacuna insofar as the legislation is concerned. It's just the application which may be a problem.
Thank you, CJ. Maybe just to clarify, I wasn't saying devolution or that there is not enough legislation, but I'm saying if you look at the plethora of legislation that relates to the land matter in our country, there are a number of those, some of which, maybe from where I sit, may be conflictual. And that's why I use the issue of the Extension of Security of Tenure Act, which deals with the protection of farm workers.
Yes.
And PI, which deals with the prevention of illegal eviction of unlawful occupation of land act, of land. So I was just saying that in your own, maybe it's something you have not looked at. If you look at all of these pieces of land legislation, don't you think it might be better for a country to revisit whether you don't need a consolidation of those pieces of legislation such that you can have one omnibus legislation? It may be okay, it may not be okay. It was more to hear what's your views about it.
Yeah, I don't think it will be a good idea. I think we should not adopt the same size fits all approach in terms of our legislation, because the problems tend to be unique depending on areas. You might find that the problems which are faced in rural areas require a certain type of solution, which may not necessarily be the case when it comes to regulating land in urban areas which is occupied by people informally. So in that case, I think I haven't thought about it, to be honest with you, but I think it may be problematic if we try to centralize everything.
Commissioner Singh?
Thank you, Chief Justice. Just two questions. Good afternoon, Mr. Nkosi. I haven't belonged to a law society, but I'm trying to understand what it means to be a member of a law society. You were born in Springs, you got your degree in KZN, but I see you're a member of the Cape Law Society and KwaZulu-Natal Law Society. What does that mean to a layman like me?
Our firm has branches in various centers of the country. We have a branch here in Gauteng, we have a branch in Cape Town, we have a branch in Richards Bay, we have the main office in Durban. And what we tend to do is make sure that our lawyers are versatile. So if I go to Cape Town and I need to do anything that needs to be done by a lawyer, I'll go to court and appear, because I'll be a member of the Cape Law Society. I haven't done the same with Gauteng, unfortunately, but that was basically the reason. It's not that I've had any reason to appear in Cape Town, but just in case. So we, as a firm, took an approach that all our lawyers should be able to appear in any office of that where the firm has a presence.
Just following on that one now, if you are appointed with your firm's presence in all these provinces, and you get one of your colleagues, you are a partner in this firm for many years, involved for 25 years, appearing in a matter for the plaintiff or a defendant, what would you do?
I'll recuse myself.
Thank you, Chief.
Thank you so much, Commissioner Singh. We took too long on you, but I just need to clarify one or two things with you. And happily, I'm satisfied that as a senior partner, you should be able to absorb the question and deal with it well. You see, I need to know what percentage of the work that you personally handle at the firm, as it relates to briefing counsel, goes to Black Council, including women, Black women?
The difficulty in giving like a definite answer to that is that it actually varies. If
Estimate.
an estimate would be about 40% of the work I give out to council, I give out to Black Professional Council. As I said, I need to qualify that
Sure.
that's based on their availability.
No. I just want to know how much has actually been delivered to them. Obviously, if they are not available, they can't have it.
Yes.
You
So-
see,
So
that's what I
think
want
the rough
to.
estimate will be about 40% of the work that I have, bearing in mind that my first port of call would be Black advocates. I would say I actually tend to give out about 40%. 40% of my work ends up in being the work given to Black advocates.
And how much of that 40% goes to senior council, Black?
I would say about 30%.
So
And
10% goes to the junior ones?
yes.
How much of the work that goes to senior white council, particularly male, do you make it a practice that you, where there are juniors involved, that Black or woman junior are roped in?
Like I said, I would actually brief seniors depending on the complexity or the magnitude of a matter.
Sure.
So because of the fact that I've been working with counsel who've become familiar with the type of work that I do, and those, and in most of the time, those are white advocates. And I'll say about 70 to 80% of the work at that level, I end up giving to senior. Well, not 70, about 60 to 70 to senior Black advocates.
You see, I'm asking these questions because you seem to be hesitant and too unsure to make one uncomfortable. When Commissioner Mpofu was asking you about this issue, availability, it looks like it's Black Council who have a problem about being available to get work from you, but White Council are always available to take work from you. And I was seeking to understand what this hesitance is all about.
The hesitance is about there are too many of the white senior council going around as compared to Black senior council.
All right.
So when it comes to finding white senior, it's actually you go through the HOTAs, you find that 80% or 95% are white.
Do you?
And then I go
Yes.
through the 5% that I would
Yes.
have preferred to brief who are senior.
Sure.
And all of them are occupied, and I
Okay.
can't find them.
Is your briefing confined to KZN or is it nationwide?
Now, in my case, it's just KZN.
Is your client or are your clients municipalities or the private sector that deals with local government issues?
It's a mix. I don't act for municipalities. I don't act against municipalities who are traditionally our clients. So if an instruction comes through, anybody wanting to act against them, I would refuse that instruction.
So traditionally you act for municipalities?
Traditionally, yes.
Have
But-
you? Yes.
Yeah, but as I say, if individuals have matters against municipalities that I don't act for, then by all means
Sure.
I do act for those individuals.
Now, have you prevailed on municipalities to have you, for the purpose of contributing to the transformational agenda, to allow you to source counsel throughout the country, Black counsel, women, because they are part of the state that ought to make sure that transformation is realizable.
I actually do it all the time. Now, you see, the thing is, some cases you find that for officials, because most of the time my point of contact are officials in the
Yes.
municipality. And when they come to you, they think their heads on the block because if they lose the case, there's going to be ramifications from the councillors or people who are actually in charge. And when I impress upon them that we should actually take a chance and, you know, and maybe brief someone who does not necessarily have the type of experience they expect, you find that there's some resistance.
Well,
so I have to try and persuade
yes.
them.
Why is briefing senior black counsel thought to be equivalent to chance taking?
No, I'm not saying in the case of black, I'm just saying the level of seniority or the experience, for instance.
All right.
So it may be black or white. If I say
Okay.
this counsel was admitted 2 years ago,
Yes.
and the claim involves 200 million, and they say, well...
No, I was
if they-
talking senior
Oh,
counsel.
okay. No,
They are
get
all over the country. Yes. Now, one last question, and I need to preface this one. I am all for judges being criticized because none of us should ever be given reason to believe that they have it open to them to criticize others, but they should not be criticized. But here is my point in relation to your article, because I believe that even as you do so, you should be careful. You can't be, for want of a better expression, reckless.
Indeed,
You can't just be free-flowing.
Yes.
Was the possibility to appease what came strongly through as the possible basis for what they did, or was the possibility for seeing issues differently, understanding the law differently by the judges just as strong or even stronger? I'm raising it, let me explain myself, because I don't think it should be an easy thing to do, particularly by an officer of the court, to say to the reading public that, you know, these people don't count much on their integrity. They can just do things to appease. Because that, just to explain its dangers, seems to suggest that when judges feel pressurized by some entity, political party or something, there's a possibility of attacks or embarrassment, they may just choose to appease. It's one of the readily available possibilities. So I just want to afford you the opportunity so that you're not misunderstood. Why did it look more as a possibility of appeasing rather than just seeing the law differently or at worst an erroneous legal conclusion?
Must admit, Chief Justice, that my choice of language may not be the best choice of words I could have used. But at the same time, I could be wrong. I'm not saying that the views I express are actually the right views. I'm just saying I expressed an opinion. I may have been more robust in the way I expressed a view, and other lawyers may read what I'm saying and say, he's talking nonsense, which I will accept. But what I'm saying is that I viewed it as constructive criticism in an effort to enrich our judiciary, that we should actually be prepared to listen to each other's criticism.
Absolutely.
Yes.
No, that I agree with. But your comment cast us some kind of an aspersion. It suggests the possibility of actually acting contrary to the oath of office, because a judge's oath of office requires of a judge to act without fear, favor, or prejudice. So if a party deserves to succeed in a case, for you to then disadvantage a party deserving to succeed by appeasing, that's not justice. That's corrupted justice. And your conclusion seems to point in that direction in some way. judges, the Constitutional Court goes out of its way to appease. Why would they want to appease? Why?
Like I say, it
You
must...
don't just appease, there's got to be good reason to depart from your constitutional mandate and appease interest groups, communities, or entities.
Like I say, Chief Justice, I think it was a wrong choice of words.
Okay.
So, and for which I sincerely apologize to the justices who sat in the matter. And it was not intended to be destructive in any way. It was just, as lawyers, expressing a view in an attempt to enrich our jurisprudence that we can also self-criticize.
Is it a jurisprudential issue to say people are appeasing?
No, actually, it's not. Maybe not belated as it is, I should have not used that word in my
No,
article.
to err is human. That's
It
why I
is.
thought it was necessary that you be afforded the opportunity to explain yourself in this regard.
And I take the opportunity, Chief Justice. Thank you very much.
Thank you very much, Mr. Nkosi. You're excused.
Thank you very much.
Oh, I'm sorry, the minister wants to. I'm sorry, Minister, I didn't see your hand.
In fact, on a light note, I wanted to say we as politicians get much heavier stuff than that in the form of outright insults sometimes. But I think that I concur with. But anyway, I agree with the Chief Justice that indeed all of us have a duty to make sure that, especially as politicians, to make sure that our judiciary, which might not in many instances be in a position to defend itself, be treated with some degree of decorum. The follow-up that I wanted to make, and I just wanted to clarify the point, because my understanding of the original question relating to the briefing of a black female counsel related specifically, that is the question itself, related specifically to those that are emerging, because I recall Honorable Counsel Mpofu alluded to baby juniors. So I just wanted to confirm if I understood correctly that your explanation about non-complicated matters being given to black female counsel would specifically relate to uncomplicated matters to allow those that are just new entrants, in fact you use the word so that they are not thrown in the deep end, but that you are not expressing a view that black female counsel necessarily deserve less complicated matters. I just wanted you to clear the air there for me.
No, in fact, I think the question was specifically directed at young upcoming black female advocates. Insofar as females are concerned, when I started practicing, the advocate was using almost exclusively was a black female advocate. And she actually worked in most of my matters to the extent that I actually had a problem when she was not available. She's since taken silk, and I'm actually waiting for the day when we're going to have black female advocates who are actually going to be available like she did.
The second follow-up I wanted to clarify for my purposes relates to the question of your remarks disparaging, well, not so much the disparaging part. No, not that aspect, Chief Justice, my apologies. It relates specifically to the understanding that one of the fundamental distinctions between the role of the Supreme Court of Appeal on the one hand and the Constitutional Court on the other is that the Constitutional Court has the added obligation not only to interpret and apply the law in its traditional classical sense, but also to ensure that there's equity in terms of the spirit and not just the letter of the Constitution. Couldn't that have been a consideration that you looked at in your criticism of that judgment? Because the way it comes across to me is that you seem to have looked at the law clinically and applied it mechanically in interpreting. I am not necessarily defending the judgment. I don't have the facts. I haven't read the judgment. But based on what you yourself are saying, that they sought to find some kind of a balance between two parties or something to that effect, isn't that in fact in line with the spirit of the Constitution, so that the principle justice must not only be done but must be seen to be done would be a case in point where that principle seemed to have also been taken into consideration?
It could be, Commissioner. As I say, I may be wrong, but that was just an opinion I was expressing at the time.
Thank you, Chief Justice.
Thank you. Just one last question so that you all know you're not unfairly, you are not disadvantaged. You used to be the Vice President of the SRC while you were at varsity. You then also became a member of SANSCO. But when you got to Shepstone and Wiley, you seem to have cut ties with similar organizations, including BLA and NADEL. Now, the opportunity I want to afford you is this. A person may think that that environment disconnected you completely from the community you come from and its interests. And that is why organizations that seek to advance interests of the previously disadvantaged no longer appeal to you. Would you like just to deal with it? I'm not saying it's your position. I'm saying you need to be given the opportunity to deal with those issues.
At the time when I went back to practice and I started practicing in my area of expertise, my clients were political parties, and that was the time when we were ushering in the new dispensation. I was coming from my own political background, which actually focused my mind in one direction. Then I had clients who came from different other political ramifications or formations who were coming to see me for advice. Then there was this thinking that, you are actually leaning towards this direction.
Have your own people.
Yeah, oh yeah. So what sort of advice can we expect to get from you? So I had to sit down and think hard about it, that I want to give my clients comfort that when they come to me, I'm not going to wear my political hat and do their work based on that. I'm going to do it as a lawyer, irrespective of who I vote for when it's time for voting. That I can do. I still have a right to do that. But as a lawyer, I took a conscious decision that I would actually give my clients who have, most of the time they are politicians. I can't distance them from that they should have the comfort of knowing that I'm not aligned to any side. I'm just doing work for them.
And that extends to NADEL, BLA?
No, it doesn't extend to that. I think when it comes to NADEL and BLA... Yeah, it's actually more of the time constraint that I had than anything else, because there was a time when I actually, I would, participate in their processes, but to the extent of becoming a member, I never got around to doing that formally, and as I say, it was not out of any ill intention or that I have anything against the organizations. I'm fully supportive of.
No, I thought you needed the opportunity to deal with the issues frontally.
Yeah. Thank you very much.
Thank you very much, Mr. Nkosi. You are excused now.
Thank you very much, Chief Justice, Commissioners. Thank you very much for the opportunity.